The main purpose of this statute is to prevent harassment or abuse. Again, the statute does not define what harassment or abuse is. It does give some examples that are pretty obvious. You don't want to use profanity or abusive or vulgar language in the course. You don't want to engage in certain conduct that's deemed harassment, and the statute provides a kind of a laundry list of situations that may provide that. But generally, harassment and abuse is not technically defined under the statute. There are some examples that we'll use. For example, one of the things that I see in my experience that has come to light within the last couple years that is specifically spelled out in 1692 D5 is the frequency of phone calls that are made by debt collectors to consumers. This could be deemed harassing based on the volume of phone calls in such a succession that makes it harassing. The case law is pretty good on this aspect. It's not necessarily given the frequency or the amount of phone calls. It's just how it's used. If it is used to cause the phone to repeatedly be made over and over again, or repeated hang-ups, or even phone calls after what I call, in the state of Florida, we call the futility argument, where a consumer has basically said, look, I'm on disability, I just don't have the money right now, and you call back repeatedly several days in a row or after that. There just comes a point in time where a court may deem that to be of harassing conduct. If it is intended to harass the court, that's obviously a jury question that would be made. But as 1692 D5 of the statute says, do not allow the phone to repeatedly be called for the intent to harass or oppress the consumer. That's just a mere example under D. 1692 D is an example of actions that would be harassment.